Good morning, everyone. Thanks for joining us today for Legal Aid's two-part training representing claimants at Social Security Disability Benefits Appeals. My name is Sylvia Soltis, and I'm a senior staff attorney at Legal Aid in the Pro Bono program. We're grateful to have you with us today. I'm joined today by my colleagues from our Public Benefits Law Unit, Supervising Attorney Nina Wu, Staff Attorney Sacha Robinson, and Staff Attorney Alana Avital. I'd like to flag a few items for our attendees. First, we're recording this training. After the training, we'll share the link to this recording along with additional training materials for you. Second, if you have questions throughout the presentation, please feel free to type them in the chat box at any time. We'll be monitoring that throughout the training. And for some, we'll be able to answer in real time, and others we may need to hold off until the end of our presentation. Rest assured, we have allotted enough time at the end of our presentation on each of the days to address your questions. Third, we'll take a 5-minute break halfway through today's training with the hope that we can all avoid Zoom fatigue and refill on our coffees. With the pointers out of the way, I want to share a little bit about Legal Aid, especially for those of you who are new to our organization. Excuse me. Legal Aid is DC's oldest and largest civil legal services organization. For over 90 years, we have been making justice real in individual and systemic ways for persons living in poverty in the District of Columbia. Legal Aid DC provides a continuum of legal services to clients in a variety of areas, including housing law, domestic violence, family law, public benefits law, consumer law, and criminal record sealing, just to name a few. We receive thousands of requests each year for help, yet unfortunately, even with our sizable staff, we simply do not have the capacity to help everyone who reaches out to us. It's why I am so grateful that you are here today with us, and hopeful that you'll consider taking a pro bono case from Legal Aid after you've completed this training. Our pro bono program allows us to expand our impact in DC by providing legal assistance and representation to hundreds of additional individuals and families each year. It's through our partnerships with attorneys just like you that we can help more people in DC. You know, navigating Social Security disability benefits, determining eligibility, and actually securing and maintaining benefits can be quite challenging without counsel. And we know that claimants who are represented by counsel have a much greater chance of securing success. So pro bono attorneys like you can make a critical difference, helping claimants obtain the benefits they need to make ends meet and to which they are legally entitled. So again, thank you for coming today. With that, I'm going to turn it over to my colleague, Nina Wu. Nina is one of our supervising attorneys in the Public Benefits Law Unit. Nina co-manages the unit and advocates for clients and systemic change in a wide variety of public benefits matters, including Social Security, food stamps, Medicaid, and unemployment insurance. Nina also serves as an expert mentor on public benefits cases to our pro bono attorneys. So if you accept a pro bono Social Security disability matter from us, there's a good chance you just may have her as your mentor. So Nina, all yours.
Thanks so much, Sylvia. And thank you again, everyone, so much for being here. We really appreciate your time. And as Sylvia was saying, Social Security benefits is an area of huge need for us. Each year, we get many applications for help in this area that we have to turn away because unfortunately, we just don't have enough resources to serve people. So we are always very grateful for the pro bono partnerships that we have and always happy to answer any pro bono attorneys' questions and help people walk through cases because we know that means that we can serve many more people. So without further ado, let me share my screen here to start the PowerPoint presentation. One moment here. Stopping sharing for a moment just so I can set this up the right way. Okay, now we're in business, great. Sorry about that delay. So when most people think about, or not most people, when many people think about Social Security benefits, they often think about the Social Security benefits they hear about in the news, which is Social Security retirement benefits. And those are benefits for people who have an extensive work history and have now reached what Social Security considers to be retirement age. What many people don't know about is that Social Security, the Social Security Administration operates two other large benefit programs for people with disabilities. One of these programs is called Supplemental Security Income, also known as SSI. So you'll hear that a lot in this presentation. And the other disability benefits program is called Social Security Disability Insurance, also known as SSDI. And so those are the two benefit programs that we'll be focusing on in today's presentation and the presentation on Thursday. So here's the agenda for today and Thursday, just to preview for you. So today we'll be talking about, I'll first be giving you an overview of SSI and SSDI. Again, that's Supplemental Security Income and Social Security Disability Insurance. And so I'll first talk to you about the differences between the two programs, the similarities between the two programs, eligibility requirements, what an award of benefits look like. So about how much do people receive when they get each benefit. And then, and this is probably what will take up the most time in my part of the presentation, how Social Security decides whether people are disabled or not. And so we'll work through the process of, we'll first look at how Social Security decides if adults are disabled. And then we'll look very briefly at how Social Security decides if kids are disabled. Then we'll take a break, as Sylvia mentioned, 5-minute break. And then we'll pick back up with Sacha. And she will talk to you about what it's like to represent Social Security clients, tips for representing Social Security clients, what the Social Security appeals process looks like. And then we'll start walking you through each stage of appeal and what to expect at each stage of appeal. So first step is the request for reconsideration. Second step is the request for hearing before an administrative law judge. So that's day one. So as you can see, we have a lot of ground to cover on day one. We have less ground to cover on day two, but it's equally as important because I would say each of the topic areas in day two is pretty dense. So stick with us for day two as well, where we'll be covering stage 3 appeal, which is the Appeals Council, the Social Security Appeals Council. And then we'll be providing an overview of what it's like to operate with Social Security cases in federal district court. There'll be a break, also 5-minute break on Thursday. And then we'll have an overview of a slightly different appeals process. And this is an appeals process for people who are already receiving benefits, but Social Security has decided they're no longer disabled. And so we're helping with their appeals. So we'll talk to you about what that looks like. But first, let's start with Social Security's definition of disability. So Social Security's definition of disability is an inability to engage in any substantial gainful activity. And that basically just means a significant amount of work activity that is likely to reach a certain income level. I'll get into that later. By reason of any medically determinable physical or mental impairment. So again, that's their standard of disability that I'll go more in depth about these mental impairments as well, which can be expected to result in death or which has lasted or can be expected to last for a continuous period of not less than 12 months. So the point I want to make here is that Social Security is intended to be a permanent disability benefit. It's not intended to be a temporary benefit. So sometimes people apply for help. Let's say they used to work at a construction job and they injured their back, perhaps they got back surgery, and their doctor says, well, you have a prognosis, or your prognosis is you should be good to go in about 3 months. You'll be able to work fully in 3 months. Unfortunately, If that's the prognosis, then they are not entitled to Social Security benefits, Social Security disability benefits. And the reason why is because, again, it's not intended to be a temporary benefit. It's intended to be a permanent benefit. And by permanency, we mean expected to last at least 12 months or longer. So now I'll start getting into what's the difference between SSI and SSDI and what's the similarities. So the similarities are both programs have the same standard of disability, meaning Social Security is looking at the exact same things to decide if a person is disabled or not. Another similarity, of course, is that both programs are administered by the Social Security Administration. But the differences are that supplemental security income is a needs-based program designed to help low-income people. And what that means is that supplemental security income has income limits because it's really only for people who are low income. Whereas Social Security disability insurance is an insurance-based program. So basically it means that people have to have enough work credits to qualify for Social Security disability insurance. Again, SSI has strict income asset limits, while SSDI requires insured status based on work history. Another point worth mentioning is that low-income recipients of SSDI can also receive SSI. And so that might happen if, let's say, a person who qualifies for SSDI qualifies for about $800 in SSDI. Well, what Social Security is saying is that we will make sure that no matter how much you qualify for in SSDI, you'll at least get the maximum benefit of SSI. So what they'll do is they will give these SSDI recipients a little bit of SSI to help them reach the SSI maximum amount, which is $914. So for the case of this person who's receiving $800 in SSDI, Social Security would give them $114 in SSI. Another thing worth noting is that people who apply for SSI are automatically considered for SSDI as well, but the reverse is not true. And so sometimes we have to check in with clients to make sure if they've applied for SSDI, that they also apply for SSI. So that way, again, if their benefit amount, if their SSDI benefit amount is low and lower than the SSI maximum benefit amount, then they will at least get some money in SSI as well to give them a higher monthly income. And so this is taking a closer look here at the differences between the two, differences and similarities between the two eligibility programs. So I'll dig a little bit more into this substantial gainful activity definition here. So substantial gainful activity basically just means a significant amount of work activity that it is expected to earn about $1,470 a month for this year of 2023. So each year, the substantial gainful activity amount changes. And for this year, it's $1,470. And so what Social Security is saying is that if you make at least $1,470 a month, then we're going to consider you to be not disabled. And so as we'll talk about later on the presentation, if somebody is working and earning more at least $1,470 a month, then they're automatically found to be not disabled by Social Security. So that's what we're talking about when you hear substantial gainful activity. I should also mention, though, that someone can be performing substantial gainful activity, but also not earning $1,470 a month. An example of that is that sometimes Social Security will consider volunteer work to be substantial gainful activity if it's likely that the person who's doing the work, the volunteer work, could be making that amount. They just happen to not be being paid. So let's say, like, for instance, a volunteer is volunteering 40 hours a week, 8 hours a day, but even though they're volunteering, because they're volunteering, they're not making any money. But if Social Security sees that they're able to perform that 40-hour work, then there's a good chance that they will find them to be performing substantial gainful activity because they could potentially earn that amount if they're actually getting paid. So again, another similarity between the two programs is in both programs, you have to be found to be medically disabled by Social Security. And that's what we'll get into again later. It's the same standard of disability. And then where things differ, again, is with supplemental security income with SSI, there is an income test. And that income test is you have to be making less than $914 a month for an individual. And whereas for Social Security disability insurance, there is no income test, but there is the work history test. So you have to show that you worked at least 5 of the prior 10 years before your disability started. So sometimes we have people who come to us and say, I worked 20 years ago, 30 years, I worked so much. I don't know why Social Security is saying I'm not insured. And unfortunately, the reason why is because after a certain period of time, people's work credits expire. And so generally speaking, if the work occurred outside of the 10-year period before the person's disability started, then they're not eligible for Social Security disability insurance. So in short, people have work credits. They develop work credits as they work, but the work credits are only insure people for a certain amount of time. And so they have to prove that they were disabled before their work credits expired, because that means that their insurance expired at that time as well. So going back to supplemental security income, we have a resource test. That means that they have to have less than $2,000 in assets. Social Security disability insurance does not have that resource test. So again, for SSDI, no income test, no resource test. The biggest hurdle is just the work history test. And then the last difference is a difference in immigration status. For supplemental security income, is a person a US citizen or quote unquote a qualified alien, which there are a lot of ways of categories of becoming a qualified alien, but you don't have to worry about any of these immigration statuses, because we would make sure that the person passes this hurdle before we would refer them to you for pro bono representation. So same thing for SSDI, different immigration status. Is a US citizen or lawfully present. So we put that there just so you're aware, but again, don't expect that to be an issue for anyone that we refer to you, because we would first make sure that that is not an issue before referring. So here's what the benefit amount looks like for both of these benefits in 2023. For supplemental security income for SSI, again, that benefit amount is $914. That's the maximum amount of benefits that people can get. There's no derivative benefits. And what that means is that if you are found to be disabled, your child or your spouse does not get any benefit from the SSI that you receive. But whereas when you have Social Security disability insurance, there are potential derivative benefits for spouses, sometimes former spouses also, and for children. For supplemental security income, there's no waiting period for the benefit. If you're found to be disabled, you can start receiving the benefits right away. And then you receive Medicaid, which is great. It's an automatic receipt of Medicaid, which is helpful for so many of our clients. For Social Security disability insurance, as you can see, the average benefit amount is typically much higher than supplemental security income. Again, it's not always higher. Sometimes people might just have a little bit of work history, enough to get them Social Security disability insurance, but not enough to help them get above that $914 a month level. Which again, if they don't get above that $914 a month level, that means that they will qualify for both SSDI and SSI. So SSA, Social Security will give them additional money in SSI to help them get at least $914 a month. And again, there are derivative benefits for spouses with SSDI. And so that's something to be aware of as well. And we can walk you through all of these technical details also. And this is these other 2 points are lesser known points as well, so definitely worth mentioning. One is the benefits can start from the date of onset of disability up to 1 year prior to the date of application. And so what that basically means is that people are eligible for back benefits up to a year before they applied, assuming they were found to be disabled up to a year before they applied. And so that's a lot of back benefit money, which is a great benefit for our client, especially if we're representing clients in their social, once you start representing clients at their Social Security hearing, then that can result in a huge amount of back benefits to clients. And going back to SSI, benefits just start from the date of application, which is still helpful as well, but it's not as generous. It's up to 1 year prior to the date of application. Another lesser known point is that for SSDI, there was a 5-month waiting period. So basically, if let's say I'm found to be disabled as of 2015, in January 2015. What Social Security is basically saying is that you're not eligible for SSDI until May of 2015. There's this 5-month waiting period, or I guess it'll be June. There's this 5-month waiting period. And the reason why Social Security has this is because they believe that very often people become eligible for SSDI, but then they start working and then they return to work. And so they're no longer eligible. So this 5-month waiting period is designed to see whether or not is to make sure that people continue to not be eligible, continue to be eligible for Social Security disability insurance. And then for SSDI, you are automatically entitled to Medicare too. And there's also another weird wait period of about 29 months. So how does Social Security decide if people are disabled? There's a 6-step sequential evaluation process. The first step is the claimant performing substantial gainful activity, again, SGA, which we talked about before, meaning are they earning gross income per month of more than $1,470 in 2023? So if the answer to that is yes, then again, they're automatically found to be not disabled, case closed. But if the answer to that is no, then the adjudicator goes to step 2. And that question is the claimant's physical and or mental impairments severe? And this is a de minimis test. Most of our clients pass this test pretty easily. It's not an issue for most cases. And basically what Social Security is saying is that impairments are considered to be severe if they're expected to last at least 12 months or longer and have significantly interrupted a person's daily routine. So if the answer to it is yes, which most people, for most people that we see the answer is yes to that, then Social Security moves to step 3. And steps 3, 4, 5, and 6 are where things start to get more complicated. And so I'll move to individual slides for that, but just so you can have a higher level look at what the different steps look like together, I do want to just go through just 3, 4, 5, 6, provide a high overview of that before we go into depth about these. So step 3 is, this is one way that people can meet disabilities, meaning if they meet this condition, then they are automatically found to be disabled for Social Security benefits. And so this step is, does the claimant have a condition included in Social Security's quote unquote listing of impairments, which is a list of medical conditions that Social Security has designated as being so severe as to prevent a person from doing any gainful employment. So this is the higher threshold for people to meet. Many clients we meet, we have a difficult time proving that they're disabled according to Social Security's listing of impairments. And I'll go more into depth in that in our next slide. But if the answer to this question is yes, then claimant is found to be disabled. Also case closed, benefits approved. Unless there is a current diagnosis of a substance abuse disorder, in which case we then jump down to step 6. So step 6 looks like, is alcoholism or drug addiction a contributing factor material to the claimant's disability? And what Social Security basically wants to look at here is, if the person has a substance use disorder, if you were to take away the substance use, would that person still be disabled? Or is it the person's substance use that's causing the disability? So, so again, for step 3, if the answer to the question is yes, then claimant is found to be disabled, great. Go to step 6. If the answer is no alcoholism or drug addiction, a contributing factor material to claimant's disability, then great, claimant is found to be disabled. However, assuming that step 3 is a no, meaning the claimant doesn't meet Social Security's listings of impairments, the condition doesn't meet the listings of impairments, then we would go to step 4, which is, can the claimant perform his or her past relevant work? And I'll get into what past relevant work is in a later slide. If yes, the claimant is disabled. If no, adjudicator goes to step 5. Can the claimant perform any full-time job? I'm sorry, let me go back to step 4. If yes, the claimant is disqualified, meaning, not disabled. So if the person can perform his or her past relevant work, then they are not disabled. And that's where the process stops, and they would get denial notice. But if they can't perform their past relevant work, then the adjudicator goes to step 5. And step 5 is, can the claimant perform any full-time job in the national economy, given the claimant's education, age, and prior work experience? And again, we'll get into this more later. If yes, then the claimant is disqualified, meaning they're not disabled because there's jobs out there in the national economy they can do. But if no, then client is found to be disabled unless there's a current diagnosis of substance abuse disorder, in which case the adjudicator goes back to step 6, which I won't walk through again. But so when you're looking at this 6-step sequential evaluation process, what you should be aware of is that there's 2 main paths where a person can be found to be disabled according to Social Security. One is with step 3, with the listings of impairments. And the second is a combination of step 4 and 5. If they can get the right answers for step 4 and step 5, then it's okay if they don't meet the listing of impairments. They would still be found to be disabled. And so many, if not most of the cases we see where we help prove that the person is disabled is by showing step 4 and step 5, that they can't, not only can they not perform their past relevant work, but there's not any job in the national economy that this person can do, given their age, education, and prior work experience. So let's take a closer look here at the listings requirements. So the listings requirements in the CFR, the Code of Federal Regulations, are divided into, they divide the body into different systems. There's one also for mental disorders, which we didn't show here. This is just a sample listing. But basically, if the claimant can show that they meet the requirements of any listing, then they would, again, be awarded disability benefits. But it's not as easy as it looks, as I said before. This is definitely a tougher threshold to meet. So looking at this listing here, the sample listing, so we have, let's say a person has a diagnosis of systemic lupus erythematosus. And so this disease, this is an inflammatory disease caused when the immune system attacks its own tissues. But just because someone has a diagnosis does not mean at all that they are disabled. They have to show that the symptoms of their diagnosis meet the requirements in this listing here. So what Social Security would do is they would look at all the doctor notes, all the medical record evidence to see if the systemic lupus erythematosus shows, for instance, there's 2 ways of showing that they're disabled. One is by showing the involvement of 2 or more organs, body systems with number 1, one of the organs or body systems involved to at least a moderate level of severity. And number 2, at least 2 of the constitutional symptoms or signs, severe fatigue, fever, malaise, or involuntary weight loss. So what the Social Security adjudicator is going to be looking for, again, is, again, not just a diagnosis. Diagnoses are never enough to win disability cases, though sometimes people think they are. It's never enough. They're looking at specific details of medical record evidence to see whether or not it proves these listing requirements are met. So again, so in this case, for SLE, it could be, you could try to prove disability with A, or B, repeated manifestations of SLE with at least 2 of the constitutional symptoms or signs, and one of the following at the marked level. And you'll hear this word marked a lot in the Social Security world, and it basically just means very severe. So you would have to show that they have at least a limitation, either their activities of daily living, maintaining social functioning, or in completing tasks in a timely manner due to deficiencies in concentration, persistence, or pace. So again, this is just one sample listing. The Code of Federal Regulations has many different listings that cover all different parts of the body and many different medical conditions. So one thing that you would look for is you would first look to see what type of diagnosis a person has, what areas of the body it affects, and then you would go from there. So assuming they don't meet the listings requirements, which again, many people don't, the next question is step 4, can the claimant perform his or her past relevant work? So again, this is a de minimis test. Most claimants, what am I saying? This is not de minimis test. This is, so past relevant work is generally work performed at the SGA level in the past 15 years. And I say generally because there are exceptions to work being relevant. Just because it was performed doesn't mean that it was relevant. So some examples might be, let's say that the person only worked at the job for about 3 months or so. Well, Social Security might consider that to be a failed work attempt. And so that would not be considered to be past relevant work. But so then what Social Security does next is they first try to decide what the claimant's residual functional capacity is. So residual functional capacity is a person's maximum ability to do sustained work-related physical and mental activities in a work setting, despite limitations caused by impairments. So what Social Security will be looking at would be to see if, based on their residual functional capacity, basically meaning based on the most that they can do, can they, given all their limitations, can they still perform their past relevant work? And if the answer to that question is yes, then again, the person is found to be not disabled. But if the answer to the question is found to be no, then the adjudicator would move to the next step. And that next step is, again, is there, sorry about that. How did I scroll down here? And so this next step is asked, is there any full-time work that this person can do in the national economy, given the person's education, age, and prior work experience? So here, what Social Security is looking at is they're trying to figure out, can any of the claimant's pre-disability skills be transferred into new work? And in order to do that, they look at a variety of things. They first, again, look at the claimant's residual functional capacity. So they try to figure out what's the most that a person can do. What's the most type of physical work a person can do? Can they do sedentary work, light work, medium work, heavy work, very heavy work? And then they next look at the person's age, education, and work experience and skill level. Again, this is all past relevant work. And then they look at what's called exertional and non-exertional limitations. And exertional limitations are basically the strength-related demands of a job. And I'll flip over to next slide to give you more examples of exertional and non-exertional limitations. And then Social Security looks at, they have what's called medical vocational guidelines, or grids, which they call it, which determine what Social Security's likely position is, considering a person's residual functional capacity, their age, education, work experience, skill level, and the exertional and non-exertional limitations. And so when they look at this chart, the chart will say like, oh, well, a person who is of this age and this education level and this work experience who can do sedentary work, that should be a finding of not disabled, or that should be a finding of disabled. And so that's what the grids are. You'll probably hear about the grids if you work in one of these cases or not. And some people don't mention the grids at all, and they just think about it in a different way. But just so you know, this is one of the things that Social Security looks at. So when we're talking about exertional and non-exertional limitations, what is that? So here are exertional limitations. So exertional limitations are sitting, standing, walking, lifting, carrying, pushing, and pulling. And non-exertional limitations are basically everything else. Many of the non-exertional limitations are mental, such as if a person has a tough time maintaining attention or concentration, understanding or remembering instructions, but not all of them are mental, right? Some of them are sensory related, or maybe environmental related, or maybe it's just related to using their hands to reach for things or handle things, or related to their posture. But these are all the things that Social Security is looking at when they consider if a person is disabled at this step here. And so they take all that information, again, these are the different things that they look at, as I was mentioning before about the RFC, in terms of what type of work can a person do? Are they limited to sedentary work? Or can they do light work or medium work or heavy work? And basically, the heavier work that a person can do, the less likely they are found to be disabled, because that means the more likely that it is that there are jobs out there the person could handle. So one of the biggest hurdles that we usually face in this area is proving that our clients cannot even do sedentary work. Because sometimes let's say a person used to do a lot of very physical labor and they can't do that physical labor anymore. They might think, well, I should be found to be disabled because I can't do all the physical work that I was doing. I was doing physical work for like 20 years or so. And unfortunately, doesn't matter to Social Security. All that matters to Social Security is there any work out there in the national economy that this person can be doing? And for most people, the toughest bar for them to prove is that they can't do sedentary work, meaning they can't do a sit-down job. And so Social Security, the vocational expert at a Social Security hearing might say, well, this person could be a ticket taker, in a factory, or they could sit in a canning factory and help put lids on cans, because that's all sedentary work. They don't have to lift anything. That's definitely one of the highest barriers to try to clear is this sedentary work. And then again, Social Security also looks at age. Basically, the older a person gets, the more likely it is they will be found to be disabled. And conversely, the younger they are, the less likely they are found to be disabled. So younger individual cases are definitely tougher than people who are older. In terms of education level, so what they're looking at here is, again, transferability of skills. I'm sorry, actually that's the skill level. So education, but it's also related to skills as well. If a person is illiterate, it's assumed they're not going to be able to meet some of the basic skills required from a lot of jobs. And so basically the higher education level, the tougher it is for you to be found to be disabled, because it's assumed that you would have many more job options open to you. And again, the skill level. So they look at your past relevant work and they say, what did the person used to do in the past? Was it skilled work? Was it unskilled work? Was it semi-skilled work? And sometimes we argue with Social Security about whether work should be considered to be unskilled or skilled or semi-skilled. But basically, the more skilled work that a person has done, the harder their disability case is, because again, it just shows that there's probably more jobs out there in the national economy that a person could do as opposed to unskilled work. And so all that to say, it's hard to be found to be disabled based on these grids that Social Security looks at this step. But you should know that the medical vocational grids are not binding when a claimant has either a combination of exertional and non-exertional impairments, or if they have exclusively non-exertional impairments. So if you go back to that list of the exertional and non-exertional impairments, most of our clients have a combination of both. And many of our clients, if not most of our clients, also just have solely non-exertional impairments. And so what we typically argue is that, yes, they don't meet the grids, they don't meet these medical vocational guidelines, but the guidelines are not binding because they have a combination of exertional and non-exertional impairments. Check time here. So step 6, again, this is a step that Social Security goes to if they believe a person is disabled, but a person has a substance abuse disorder diagnosis. So the question is drug or alcohol addiction a contributing factor material to the claimant's disability? So again, they must have a diagnosis of substance use disorder. Use of drugs or abuse of alcohol without diagnosis is not enough to find materiality under this step. And I want to highlight this because sometimes administrative law judges get this wrong. They skip the step. They see some drug use in there and their flags go up and they say, are the drugs causing this disability? But no, that should not even be an issue if there's no diagnosis of substance abuse disorder. Second, we have to show that the impairments caused by the disability are separate from those caused by substance abuse disorder. And the ways that we try to do that, there's a few ways we try to do that. The first is we often try to show that the symptoms predate the person's substance use. So it's sort of like which came first, the chicken or the egg, right? In this case, we try to show that it's really the symptoms that came first. And as a result of the symptoms, the person started using drugs and alcohols as a form of self-medication. That's their way of coping, right? Because unfortunately, sometimes the people with the most severe mental health issues that you see, for instance, sometimes the people you see sleeping on the streets, they have a lot of problems going to see doctors, whether because of trust or paranoia issues or their physical or mental disability issues. They have a lot of trouble meeting appointments and keeping appointments. And so they don't have the medical record evidence needed to prove their Social Security disability case. maybe I'm going off on a tangent here, but so all of that to say is that so you have to show that the impairments caused by the disability are separate from those caused by the substance use disorder. And so another way that we look at this is that by trying to see if the person has any periods of sobriety in their past. Because if they had periods of sobriety in the past, and meaning they weren't using any drugs or alcohol, but they were still having severe mental health symptoms, well, that just goes to show that drug or alcohol addiction is not a contributing factor material to the claimant's disability, because you can see from this period of sobriety that, look, they were clean, but they still have all these severe mental health issues. And there's a specific Social Security ruling that offers additional guidance on substance abuse and gives examples, which is really helpful. And so it's Social Security ruling 13-2P. And sometime after our presentations, Sylvia is going to email you all a training manual that we've been working on that goes through all of these topics in depth too, just so you know. This is not your one and only chance to learn about all this information. So last but not least, I want to talk about SSI for children. So as I mentioned before, people, not just adults, can qualify for supplemental security. Children can also. And there's a 3-step, but I should also say, but the SSI that children receive is based on their own disability benefit, meaning it's not a derivative benefit. It's not from their parent. This is about them proving that they are disabled. And for children, for child SSI, there's a 3-step disability analysis. The first is the child performing substantial gainful activity? And usually the answer to that is no. Second is, does the child have a medically determinable impairment that is severe? Again, the answer to that is usually yes. That's usually pretty easy to meet. And then the third, and this is where people face more of the challenges, is does the child's medically determinable impairment meet medically equal or functionally equal a listed impairment? And just to note that functional equivalence means that the child has 2 quote unquote marked, meaning very severe limitations, or 1 extreme limitation in the following areas. And so that would be acquiring and using information, attending and completing tasks, interacting and relating with others, moving about and manipulating objects, caring for yourself, and general health and physical well-being. As a part of this analysis, this step 3 analysis, one thing that judges are supposed to do, but often get wrong because they don't see a lot of child SSI cases. I think many parents just sort of abandon their claim earlier on, and so don't take their cases to hearing. And so a lot of judges forget that there are regulations that say when they're considering this step 3, they're supposed to be considering what's called a whole child. They're supposed to be performing what's called a whole child analysis. And what that basically means is that they're supposed to be looking at all these different things. Not only are they supposed to be looking at all these different areas I've mentioned, but they're supposed to be comparing them to what an average child, how an average child at that age would perform. And they're also supposed to, and this is what they often typically forget, is they're supposed to take into account any special supports the child is receiving. So is a child in special education? Do they have an individualized education plan? And if so, what are the accommodations that they get through their individualized education plan? Do they get frequent breaks? Do they get more one-on-one attention? Do they sit closer to do they have preferential seating? Because sometimes what judges will do is they'll say, well, yeah, the person has all of these diagnoses and looks like they have an IP, but according to their grade reports show that they're doing just fine. So that child can't be disabled, but that's not true. And so the question that they're supposed to engage in is what happens if you were to take away all these special supports, all these accommodations? How would the child be performing then? Would the child have impairments that would be considered to be marked or extreme? And if so, then that child should be found to be disabled. So that concludes my portion of the presentation. Thank you so much for sitting through this. I know it's a lot of information that I'm throwing out there. I want to stress again, don't worry about having to memorize this stuff. And we have an extensive training manual we'll be sharing with you with specific briefs, sample briefs, and stuff like that. And if you were to take one of these cases, we get a mentor who's very eager, enthusiastic to help But for right now, we will take a 5-minute break. And when we pick back up, then Satya will start going over what the Social Security appeals process looks like. So thank you very much, everyone. And please join us again in 5 minutes.
And we can go ahead and get started with this second half of today's presentation. So Nina talked today about the law of Social Security law and how to meet the standard and what's required to meet the disability standard. In the second half, I want to talk more about some of the practicalities of what do you do when you now have a case? What are the steps for you, the case handling attorney, to prepare the client for the process, to prepare written materials that you might be submitting. And so I want to talk through tips for case handling and tips for working with clients and going through this appeals process. So one thing to keep in mind is that these cases involve really sensitive and personal health information. And so your representation might require some difficult conversations with your client. It might involve intimate personal details, substance abuse, as Nina mentioned. A lot of times our clients have experienced trauma and their health conditions might be related to past traumatic experiences. Sometimes our clients have unreported income and we'll need to get more information about, what their work history has looked like, whether that has been reported income or unreported income. Our recommendation is that you wait to build trust with your client before having these really sensitive conversations. And another way of thinking about this is putting yourself in your client's shoes. And when you've had kind of personal, professional interactions, thinking about whether you're comfortable sharing really sensitive information with someone you've just met, or if that information might come easier at a later point once you've established a rapport. A lot of these cases involve clients who have mental illness or mental health conditions. And so we encourage you to think about ahead of time how that might impact your meetings and your interactions with the client. And so, you might want to think about whether they might need reminders for appointments. If you are having any difficulties with communication, kind of rethinking and checking in to make sure that everyone's on the same page and understanding what's happening. And you might also want to think about the supports that people have in their life. Do they have a caseworker? Caseworkers can be really key resources when you're working with someone who has a mental health condition, because they might have a lot of familiarity with the client and already play a key role in helping support them in their life and daily activities. Something else that we encourage pro bono attorneys to think about when taking these cases and before having their first meeting with a client is how income might impact representation. So oftentimes, our clients might have have limited phone access. So if someone's phone number goes out, do you have a backup way to get in touch with them? Is there another phone number that you can use to reach them, or do they want you to send a letter? It can be helpful ahead of time to think through what the backup method of contacting them would be if there's some issue with phone access. Also think people might miss meetings. It's very common that sometimes folks will miss meetings or have limited access to technology if you need them to sign something on a computer. I think we often encourage folks to have some grace and understanding when people perhaps miss or forget appointments. There are some special issues in child SSI cases. So in these cases, the client is the parent, and they are the client on behalf of the child. And so at the beginning of the representation, it's really important to establish that, you can't keep secrets from the parent. So if the child tells you something, you want to make sure that they know that all of the information is being shared between the parent and the child. There are some things that might come up in child SSI cases. You know, the parent might need some assistance with, you know, transportation or working through issues with communication. There are some kind of special barriers that come up in child's cases. Okay, so this chart demonstrates the appeals process that someone goes through from start to finish in a Social Security disability case. So the first step is that someone submits an application to Social Security for disability benefits, whether that's SSI or SSDI. Social Security will take that application. They will consider the financial information to make sure that they meet some of the basic, you know, whether they're eligible for SSI or SSDI. There's an agency called the DC Disability Determination Services, or DDS, and that agency will review the medical records to make the decision about whether someone is disabled. Once a decision is made, the individual has 60 days to appeal any denial. So the next 4 stages of the appeals process are where legal aid will refer cases out to pro bono attorneys. So it's very possible that you as a pro bono attorney would be taking a case at any of these steps. So the next step is the request for reconsideration, where again, you know, someone has submitted the appeal within 60 days, and DDS, the Disability Determination Services, will be reviewing the medical records, and that's de novo review, and making a decision. A lot of cases are denied at the request for reconsideration level. And so, you know, we strongly encourage folks to appeal again to have a hearing before an administrative law judge. This is an opportunity to have a hearing, be in front of a judge. It can be a really impactful stage of the appeals process. And so it's de novo, you're in front of a judge, and we will spend a lot of time today talking about hearings. If someone's denied at the hearing stage, again, they have 60 days to appeal. And the next step is the Social Security Appeals Council. And so review here is discretionary. They're reviewing for Alana on Thursday. We'll talk more about the Appeals Council review process, but it is different from all the stages before it. And then the last step of the appeal is going to federal court. So you can appeal these up to federal district court. The rules of civil procedure apply. And again, the review is discretionary. We will be spending a lot of time on Thursday talking about the Appeals Council and Federal District Court. But we do, you know, strongly encourage pro bono attorneys, you know, in the case of a denial, to really consider representing someone at the next stage of the appeal. These benefits can be, you know, life-changing, and they're long-term permanent benefits. And so, you know, each stage has a different chance of success. And so there's a chance, there's a strong chance at the hearing stage and federal district court stage. And so there can be a lot of benefit to helping a client appeal to the next stage in the event of a denial. Okay, so that first appellate stage is the request for reconsideration. So if you're handling a case that is at the request for reconsideration level, here are some tips about preparing your client and preparing, you know, the record for Social Security. So you should meet with the client, explain what the process is, what they should expect, and your role as an attorney. Most reconsiderations are denied. There's about an 85% chance of denial at this stage. And there's not always a lot that attorneys can do to make a difference. However, we still will sometimes refer these cases out to pro bono attorneys because it gives them time to start gathering medical records and strengthening and preparing the case for the hearing stage. And so you can get connected with the client, you can stay in touch with them and help make sure that all the appeals are filed timely in the event of a denial. If you're able to gather medical records before a reconsideration decision is made, then you should submit those records to Social Security. There's no guarantee you will receive records before the decision is made. And so there's no guarantee to the client that you can submit them before a decision is made. But we do encourage that. And if you have time, it can be great to write just a short cover letter flagging what the most important parts of the medical records are. At this stage, a client should be signing a retainer. You should have them sign medical release forms for each provider. And you should also have them sign a form 1696, which is your appointment of representative, notifying Social Security that you are their attorney in this case. It will also give you access to the individual's medical records and file that Social Security has. If an individual a claimant has copies of paperwork, you should make a copy of anything that they have. And this is a great time to ask them about medical information and their medical conditions. So that type of information includes who do they see, what providers do they go to, how often do they meet with providers, what are their most significant symptoms, and etc. There's lots that you can ask at this stage, and you can really start building your relationship to have those sensitive conversations down the line. It's also a time where you can discuss other public benefits that might be available to them. Again, these are usually folks who can't work due to a disability. And so, we at Legal Aid encourage you to make sure that they're taking advantage of all the benefits that they might be entitled to, such as food stamps, interim disability assistance, which is a DC cash assistance program for people who are waiting for an SSI decision, and temporary assistance for needy families, which is a cash assistance program for families with children. So we're going to spend most of today talking about the administrative law judge hearing. There's a lot that can be done here as you, the attorney, and your client can do to really strengthen the case and make a difference. And so we'll talk today about the primary tasks, writing the brief that will be submitted, what the filing procedures are like, how to prepare for that hearing that you'll have before the judge, and additional resources and support. Okay. So first, again, this might be the first time you're meeting with a client if you did not help them at the reconsideration stage. And so at the first meeting, you'll want to explain the process, what to expect, and what your role is as the attorney. Again, have them sign these same forms, a client retainer form, medical release forms for each provider or hospital that they visited. And that form 1696, if you haven't already, that notifies Social Security that you will be their representative for the case. Again, this is really an opportunity to go in depth and talk about their medical conditions, what their daily life looks like, how their medical conditions might impact their daily life, and what their routines look like. It's a great time to be gathering that information and building rapport. Once you've taken a case, you should submit the necessary forms to Social Security to register for the Electronic Records Express, or ERE. And the ERE is an electronic file system that Social Security has, has compiled all of the files, work history. They have some medical records about the claimant, and so it's really a great resource to see what Social Security already has about your client. It's also a method of submitting files, and it can be a delayed process. So we encourage you to start the process as soon as possible. You also should submit your 1696 appointment of representative form to Social Security, and that will ensure that you have access to the ERE and that they will mail notices to you about the case. So one of the most important steps and tasks at this when you're handling a case at an administrative law judge hearing is gathering medical records, reviewing those records, and then strengthening your case. So once you have those HIPAA medical release forms signed for each provider that your client has visited, you'll want to submit medical requests. You'll have to wait a little bit to get those records back. So it can take the provider some time to comply with the requests. But then once you have that, you'll want to review the medical records and start summarizing and pulling out helpful and relevant information. You'll also want to think about whether there are any doctors, therapists, caseworkers, any sort of medical personnel that you might want to ask to write a letter of support. A letter of support can be a really great way to strengthen the case and make sure that Social Security is hearing medical opinion from the individual's primary treatment team, and can be really powerful and persuasive evidence in these cases. So if your client has a close relationship with a doctor or a therapist or a psychiatrist, and you think they might be willing to write such a letter, I encourage you to start early contacting those individuals to see if they might be willing to support the case in that way. Another part of the record are disability reports. Periodically, Social Security will send the client a disability report form where it has some, questions about the individual's routine, what they're capable of doing, what they struggle with. And so, we encourage you to help your client fill those forms out and provide as much detail as possible. Because oftentimes a question might say something like, do you grocery shop? And so the answer might be yes, but the full answer might be yes, but I have to take breaks in the store because I get tired from walking, or sometimes I have to leave because I get overwhelmed by the crowd, or it takes me 3 hours and I go once a month and I'm completely exhausted for, days on end from going on a trip, or someone helps me, right? So I think as providing as much detail as possible to give answers, context can be really important and a really helpful way to strengthen the case. The more detail, the better, basically, at this stage. And, I think strengthening the record is a role that not only you play by helping, get a letter of support from a provider, but your client is also engaged in that process of strengthening the record. And so at the early stages, we encourage you to talk with your client and explain that, they strengthen the case by keeping appointments with their providers, going into detail with their providers about the issues that they're experiencing, making sure that they're really talking in detail about everything that they're going through. If there's sometimes if there's evidence in the records of someone not complying with treatment, that can play a role in the case. So really just having those conversations with the client about how they themselves can work to strengthen the record while you're waiting for a hearing to be scheduled. The last kind of primary task is preparing for the hearing. And so that preparation mainly takes form of a written brief to supplement the medical evidence, supplement and summarize the medical evidence. And we have some sample briefs in the training materials. And there are also some additional steps that you can take to prepare your client for the hearing. And so we will talk about that in more detail in a few slides. One tip is not to wait until you've already finished your brief to submit the medical records. We encourage you to submit medical records as you get them. That will help you down the line because Social Security will have had time to look through them and also to exhibit them and get it in a format where it's easier for you to write your brief and cite to them in your brief. In addition to medical records, as child SSI cases have some additional evidence that you should consider gathering. And so you should request records from the child's school. So relevant records include report cards, individualized education programs or IEPs plans, 504 plans, any special education records, disciplinary reports, if there are any, and any other activities that might document the child's performance or behavior. In addition, we talked about letters of support from psychiatrists or therapists. You might also consider having the child's teacher complete a teacher questionnaire, which is a special form, to provide some additional detail about the child's performance and behavior and ability to kind of meet targets and whether they're on track to be a peer, how they compare to their peers. So there are a few obligations for claimants and their representatives. So you as the representative must inform Social Security about all evidence that relates to the disability claim. So that includes both favorable and unfavorable evidence. So you can't kind of remove records that include harmful facts. You must submit all the evidence that you requested and received in its entirety. So again, you can't kind of remove some records before you submit the medical records to Social Security. There are some exceptions where you don't need to submit any work products, attorney-client privileged information or documents, or instances where the judge tells you not to submit certain records. So for example, the judge might not want you to submit any duplicative records. A last kind of important obligation that I want to mention today is that if you were able to obtain a letter of support from a doctor or other medical professional, you must disclose if you were involved in the drafting or preparation of that opinion. And so I believe we have some examples in the manual that we will be providing you. You also could ask for examples from your pro bono mentor about how to go about disclosing if you had any role in drafting or preparing that medical or vocational opinion. Okay, so preparing for the brief. You will have gathered the medical records at this point, given your client advice about how to strengthen them, played your own role in strengthening them by gathering letters of support. And so now you should be reviewing the medical records and focusing on discharge statements, treatment notes. There might be sometimes summaries of visits. Those can be really important medical records. You'll want to create some sort of organizational system to keep track of the important information. So one option is using a chart to kind of keep track of all the symptoms and the medical conditions. It also can be a way to keep track of really important quotes. So if you're reading through the medical records and you see something written that would be really helpful just in its entire format, it can be really powerful and compelling for the judge to read what the doctor or medical professional said in their own words. So, another way of thinking about this is that if you think Social Security, a judge sees you, the representative's summary of the medical records, and they might need to double check to make sure that you're accurately summarizing the medical records. But if they see a direct quote, and that direct quote is really powerful, then there's no kind of skepticism built in while the judge is reading through that. A last kind of consideration as you're in the kind of pre-writing stages of the brief is whether when you were reviewing the medical records, is there a symptom or diagnosis that your client told you about in one of your initial meetings that you have not found in the medical records? So is there a kind of significant condition that so far the medical records do not cover? If so, you should absolutely discuss that with your client. This is an opportunity for you to strengthen the record, and engage in a conversation with them about, whether they have a doctor who they might be able to talk to about that condition, kind of, what's going on here, if they've thought about discussing it to a doctor but haven't for some reason, or perhaps they just need help connecting with a specialist. And so in that case, is there any role that you can play in helping connect them and help them find a specialist who can talk to them about that condition and start creating medical records, so that Social Security can see additional proof that the individual is experiencing a certain condition or diagnosis. Okay, so you've done all of the pre-planning stages, you've reviewed the medical records, you've summarized them. Now you need to draft your representative brief. So this is something that will be written and submitted at least 5 business days before the hearing. And this is an opportunity to provide a vivid picture of the individual to the judge. And so in what you should aim to do is provide a clear link to the medical records and to the functional impairments that the individual experiences. So you want to direct the judge to important and helpful medical evidence. These briefs should be short but compelling, so short and sweet. You don't need to restate the law, the regulations, the rulings, the statute, kind of the steps of the sequential evaluation process that Nina discussed. But what you should do is discuss the facts that support a favorable finding at each step of that sequential evaluation process that Nina discussed. You can cite, you don't need to restate what the law is, but you can cite to cases, statute, and regulations if you would like. Okay, so once you have documents and briefs to submit to Social Security, you want to go about submitting them as soon as you can. So one of the first steps you should take is, once the client signed that 1696 form, which is the appointment of representative, you want to fax that to the Social Security hearings office. That hearings office is called OHO, the Office of Hearings Operations. And so you just want to get that faxed into them as soon as you can. You'll also want to submit the medical records and the brief to the Office of Hearings Operations. And so you can do that through the Electronic Records Express, ERE. That is the quickest, fastest, most efficient, and recommended process of submitting records. Again, it does require you to register for ERE, which can take some time. So start that process early if it's your first case. If you don't have ERE access, there are other ways you can submit evidence. So you can request that the Office of Hearings Operations send you a barcode. And so sometimes they'll send it in the letters that they're sending anyways, but it will have a barcode with a bunch of numbers, so that and that should be the cover sheet that you use. And you can then fax medical records and your brief to Social Security with the barcode at the very beginning. You will want to limit each fax that you send to no more than 50 pages. And sometimes when you are sending large faxes can fail. So if you are close to the deadline to submit, you want to make sure that if you're faxing your records, you really want to build in time to make sure that all of your faxes go through. That's one reason why the Electronic Records Express, ERE, is so much simpler and faster and more efficient. All records, medical records and brief, must be submitted to Social Security 5 business days before the hearing. So Social Security disability hearings are fairly informal. There's no opposing counsel. And depending on what your client selects, that hearing can happen in person, by video, or by telephone. We usually recommend in-person hearings, and Social Security is scheduling in-person hearings regularly. Again, there was a long time that they were not having in-person hearings, but those have restarted. And generally, the hearing happens in two major parts, there are two major components to a hearing. So the first component is the claimant's testimony. So the judge might ask the claimant some questions. You should prepare your client for the judge to ask them some questions. And you will also have the opportunity to ask questions. Each judge has a different preference of whether the judge will go first with asking the client questions or whether the attorney will go first asking the client questions. You should expect that the judge might interrupt your questioning to ask for more information or to clarify. It's also not, the judge may ask the representative to present or defend some of the arguments that were made in that written brief that you submitted. The second kind of main component of the hearing, right? So the first component is the individual claimant's testimony, and the second major component is the vocational expert's testimony. So this is a third party that the judge will have called to the hearing, and this individual is supposed to be an expert on vocational matters, and they're there to weigh in on steps 4 and 5 of the sequential evaluation process that Nina discussed. So as a reminder, this is the stage where Social Security is trying to determine, can the individual perform their past work? And is there any other work in the national economy that the individual can perform? And this is based on the individual's, the individual's age, education, and experience. So the judge will then ask a series of hypothetical questions to the vocational expert. And the judge will pose these hypothetical questions describing limitations that may or may not apply to the client. And the vocational expert will respond to the questions by saying whether or not the person the judge described could perform work. You will have the opportunity to cross-examine the vocational expert. And in another slide, I will talk a little bit more in depth about how to prepare for cross-examining a vocational expert, but it's an important stage of the hearing. And this is an area where if you have questions or are feeling some discomfort about it, you can reach out to your legal aid pro bono mentor to ask for some additional tips and help think through your specific case and questions that might come up at the vocational expert testimony. So if your client chose to have a phone or video hearing, there are some tips that you should give them. You want to tell your client to make sure that they are in a quiet place with a good phone or internet connection if it's a video hearing to participate in the hearing. So you want to make sure that the judge will be able to hear the individual and that the individual will be able to be in a private place where they can share, sensitive health information. This is you want to set these expectations at the beginning so that your client's not, riding the metro and calling into a phone hearing or some other sort of loud, non-private space that would make it challenging to have a hearing. You also will want, the hearings office will include the phone number that they're planning to call the client and the attorney on in the hearing notice. So you want to make sure that that phone number is correct for both you and the client. So if your client's phone number changes, that's something where you'd want to contact the hearing office before the hearing to make sure they have the most up-to-date information to reach the client for the hearing. If you're having a video hearing, a link, a Teams link will be emailed to the client and the attorney. So you want to make sure that your email addresses are accurate with Social Security. If you and your client are located in physically different places, then you might want to consider an alternate method of communicating with a client during the hearing. So is there another phone that they can use where you might be able to text them if some sort of issue arises, or if there's some communication, there's some information you need to convey? Perhaps you can email them. Another thing to consider is, as we are getting closer and closer to recovering from the pandemic and things are reopening, consider being in the same place as your client for the hearing, even if it's a phone or video hearing. So perhaps your client may be able to come into your office, and you two can be called from Social Security and be on speaker in the same room. I think that can be a really good option for clients if they want to have a phone or video hearing, but it can ease the representation. Okay, so I want to go back to vocational experts. Like I mentioned before, the judge will ask the vocational expert about the individual's ability to do past work, so that's step 4, and to adjust to other work in the economy, that's step 5. The judge will pose questions to the vocational expert. And so they will describe a hypothetical person whose age, education, work history, and physical and mental limitations are equivalent to the claimant's. The attorneys have the right to cross-examine the VE, particularly if the attorney thinks that the judge's description leaves out key limitations. So for example, the judge might pose a hypothetical. And so say, vocational expert, take a hypothetical person who can stand for 6 hours in an 8-hour day. Can this person perform the past relevant work, right? And the vocational expert might say yes or no. But suppose you think, okay, the judge's hypothetical said they could stand for 6 hours in an 8-hour day. But based on your review of the medical evidence, you think your client can only stand for 1 or 2 hours in an 8-hour day. So then you can pose a hypothetical to the vocational expert and says, vocational expert, take a hypothetical person of, the claimant's age and education who can only stand for 1 or 2 hours in an 8-hour day. Can they perform the past relevant work? So that's an example of how the judge's description of the conditions of the claimant might differ from your arguments about what the claimant's limitations are. And it's really important to cross-examine here to make sure you're getting good evidence in the record. When you're cross-examining the vocational expert about mental health limitations, judges will generally require your question to be phrased as a reduction in performance capacity, rather than using the Social Security lingo of moderate, marked, or extreme limitations. Vocational expert, some good tips to know, and this can help you frame and pose some questions to the vocational expert, is that vocational experts commonly testify that if an individual misses 2 to 3 days of work per month on a regular basis, that individual is unemployable. So that means if you think your client, based on mental health or physical health conditions, would miss 2 to 3 days of work per month on a regular basis, then that means that the vocational expert will say your client cannot perform their past work at step 4, and they can't perform any other work at step 5. So that's really important testimony to get on the record if you think your client's medical records support that type of finding. Another really common limitation that comes up in these types of cases is whether someone's ability to be on task or off task. So vocational experts will usually testify that being off task from assigned duties for 15 to 20% of the workday will render someone unemployable. So if your medical records show that someone has difficulty concentrating, paying attention, they get easily distracted, they need lots of breaks, things along those lines, they would be late. And so they would be missing, they would be late returning from breaks. They need a lot of breaks. So that type of information, if that is supported by your medical record, this is a really important question to ask the vocational expert, because you want the judge to find that your client can't work at steps 4 or 5. And so this can be a helpful way to get the judge to make that finding. When you are thinking through your questions to the vocational expert, you should review Social Security rulings 85-15 and 96-9P, because those two Social Security rulings, which you can just Google them, they can be hard to find on legal research databases like Lexis or Westlaw. But these rulings give some additional guidance on how non-exertional, so those non-physical limitations or mental impairments might reduce the number of jobs available to the individual. Once you have a hearing, you will then get a decision sometime later, usually in the mail. Usually a decision is not made at the hearing. If the judge's decision is unfavorable, we strongly encourage attorneys to take strong, meritorious cases to the appeals council, and then later to federal district court. So I mentioned I had that chart when I started my part of the presentation today, going through the different appeals steps. And I mentioned that the request for reconsideration stage can be tough to win, but it can be good to get connected with a client at that point, help them strengthen the record, help build rapport, develop trust, and really put the case in a strong position for the hearing, which hopefully you will represent them at the hearing. Hearings have a better chance of success than reconsideration, but we have been seeing in recent years that the success rates at hearings are going down a little bit. So lots of strong cases will still be denied. And so we encourage pro bono attorneys, you've developed this relationship with the client and put in all this work at the hearing stage to try and help them get these life-changing benefits. And so we encourage you to consider taking that case to the next steps. We will talk on Thursday about the Appeals Council and Federal District Court review, but we do hope that after Thursday's presentation, you feel the same kind of excitement and optimism that continuing these cases can really lead to success at a later stage. So I want to end with some resources and support available if you take these cases. So if you accept a case from legal aid, then not only will you have access to legal aid's training materials, which we will be sending you, and we have the information here on the website about how to access them. You also have access to Pro Bono Net, which has a public benefits library. You also should think about whether there are other folks at your firm or your employer who have taken Social Security cases before. You might already have kind of a hub of expertise that is growing within your firm from colleagues who have taken these cases. And then last but not least, very importantly, you are assigned a legal aid mentor who will be available to you to answer questions that arise at each stage of the case, and are there to help you think through the tricky challenges or issues that could arise. So with that, we can pause here to answer some questions. And thank you so much, everyone, for listening along today. As Sylvia mentioned at the beginning, we will be having part 2 of this training on Thursday at the same time from 10 to noon. But I will now mute, and we will accept questions in the Q&A.
Satya, it might be worth us considering reviewing some of the questions that came in through the Q&A or through the chat box so that for folks who are watching the recording later, we know that they know that we've addressed those questions as well.
Okay, great. Let me just catch up on the questions that were asked and answered while I was presenting. But I can start with some of the ones that came in right at the end of the first task. So we have one question here. If a 37-year-old claimant has never worked and most likely will not meet a listing, can that person get benefits, possibly get benefits for not being able to do past relevant work? So this is a question about step 4. So we have a response here. If that individual does not meet a listing, which as a reminder is step 3 of that sequential evaluation process that Nina discussed, and which I will pull up on the slides as we're talking. There we go. So if someone does not meet step 3, they don't meet a listing, then the judge will move to step 4, which is past relevant work. And if there is no past work history, then there's no past relevant work they could perform. So the judge will move to step 5, which is where they look at whether the individual can do any full-time work in the national economy. And so they will look at what that 37-year-old can do. And it's possible that that claimant would win at step 5. It would depend on the severity of any non-exertional limitations that they have. There was another question. Is there an income limitation for children applying for benefits? Do the parents' income impact a decision? So this question is getting at the fact that there is that SSI has income requirements. It's a means tested program. And there are income limitations for kids who are applying for child's SSI. It is not the same income test that is used for adults applying for SSI. There is a formula that Social Security uses, and that formula takes into account the number of people in the household, the total number of people in the household, the number of non-SSI recipients, and then uses that to come up with a portion of the overall income, which is deemed to the child. Let me look through and see if there are any other questions that had come in. Okay, so there's another question regarding the alcohol and drug dependency test. So this is alcoholism or drug addiction a contributing factor material to a claimant's disability? We're down here at step 6. Is it expected that the client be evaluated for a doctor to determine whether there is a diagnosis before arguing that there has been no diagnosis before so I think this is a really interesting question, whether Social Security will require a doctor to make a finding that they do not have a substance use disorder. But the answer is no. There is no expectation that the client be evaluated for this in particular. It's more a matter of whether in the regular course of that individual's meetings with medical professionals, they have been diagnosed with a substance use disorder. There was a question here. Can you please provide some explanation of when or why Social Security may request that you fill out a 1699? So that's a form that Social Security requires you to fill out when you're trying to get access to ERE. After submitting a 1696, which that's the form that notifies Social Security of your appointment of representative. So this is even if you're providing legal aid pro bono. So we have a response here. The 1696 appointment of representative form appoints you as representative, while the 1699 form is the form that informs Social Security where they are to mail you copies of the Social Security notices, even though you're waiving payment. So that's one reason. Nina or Alana, do you want to go through any of the other questions as I'm looking through?
Sure, yeah, and maybe we can actually, in the interest of time, maybe we can jump to the live questions we have now. Sorry, let me just turn off some sound notifications. So one of the questions we just received is that we haven't answered yet. Are you seeing any trends in whether SSI or SSDI are approved? And that's a great question and one that we're happy to talk about. Generally speaking, yes, the answer is yes, we have seen trends. Unfortunately, we've seen some unfavorable trends. So it used to be that in past years, we would typically just get favorable, us and pro bono attorneys and advocates across the US would see a lot more favorable decisions at the hearing stage, hearing before administrative law judge. And now that's not the case, I would say. We're seeing a lot more denials. Although this past few months, we have started seeing an uptick in favorable decisions again in that area. And we're trying to figure out if it's just because of two judges that we've identified as being much more claimant friendly or not. But for whatever reason, we've seen, for whatever reason, including we think that it's because there's been a lot more congressional scrutiny on the Social Security program on terms of how much money they're spending. And there's been a lot more pressure on administrative law judges to find less people disabled, we believe. But so for this reason, that's why we started taking more cases on appeal. So we take cases on appeal to the Appeals Council and Federal District Court. And Federal District Court is really where we see, as Alana will talk about tomorrow, that's really where we see much higher success rates. And again, that applies across the board, across the country too. Generally speaking, the success rate there is about around 50%, 40 to 50%. And then assuming the person gets another hearing, then we typically see positive results at that hearing on remand as well. And then we're talking about tens of thousands of dollars of back benefits for clients. So this is why we're trying to continue encouraging people to appeal more and more of these cases. Next live question is how to meet the $2,000 asset in SSI after a person has been receiving SSI monthly. Do they need to spend all SSI timely? Usually, how often is a review of SSI? The SSI review will be notified how long time before. So there is a certain amount of time. There's an exception made for the resource limit for the amount of SSI that a person receives, meaning you can hold a certain amount of SSI above the $2,000 asset limit for a certain period of time. I don't remember the rules off the top of my head, how many months that is, but there is an exception made for SSI specifically being in a person's bank account and causing them to bump up against that asset limit. But I mean, and the reason why there is a sort of time limit on how long people have to spend is because it's supposed to be a needs-based program, right? So the assumption is that you're very low income, if you need it, then you would spend it. But I mean, that's not necessarily good public policy, but that's a whole separate discussion. Usually how often is a review of SSI? It really just depends on what the person's disability is. If the person, some disabilities, there might be where improvement is expected sooner rather than later, then a person might have a review of their disability sooner rather than later. But usually I would say on average, it's about once every 3 years, 3 to 5 years, I would say. And next question is, can you explain if the SSA form 3441 must be submitted prior to the hearing if it was already submitted at the reconsideration stage? And so just for people who don't know, SSA form 3441 is it's a disability report. It's basically where you go through and you talk about what activities of daily living a person can or can't do, or how their conditions affect their activities of daily living. And the answer to that question is you don't have to, but it's very helpful if you do, because it's another way of strengthening the record, especially because oftentimes when people are submitting these forms at the reconsideration stage, it's like a couple of years prior to the date of the hearing. Most of these people are submitting these forms without the help of anyone else. And ALJs rely heavily on these forms, actually. We often see ALJs in their decisions going back and comparing what a client says at the hearing to what they said in their reconsideration form, disability appeal report form, even if that form was submitted like 3 or 4 years before the hearing. And it used to be the case that you would have to wait about 2 years for a hearing for a Social Security judge. So even if it was like 3 or 4 years before the hearing, they submitted this disability report, the ALJ would still use that for credibility determinations. And so it's very helpful to submit an updated version of this form closer to the hearing to make sure you're getting an accurate representation of what the client's disabilities are like, and that you're providing nuance and you're helping to flesh out all those things that the client might have said before in their other form, but not realize that they were sort of shooting themselves in the foot. Like, so for instance, let's say the person says like, yes, I can go shopping on my own. Yes, I can take public transportation on my own. But what they don't mention is how long does it take them to go grocery shopping? For instance, like, I once had a client who then said, well, yeah, usually takes me about like 3 or 4 hours to go grocery shopping because they have trouble reading and they, might have a panic attack while in the store. They start to feel a lot of anxiety. And so these are the sort of nuances that it's helpful to have an attorney go through with a client to make sure is being reflected in these disability reports. And I think that that's all the questions here that we received recently. Any other questions? And so maybe we can go back to this, the chat. We'll just do one more and then we will release people. So one question here was, we received an ALJ hearing scheduled for 2.5 months after we submitted a request for a hearing. We are thinking to ask for continuance as we're not sure. Sacha, we didn't already go over this question, right? Okay, great. As we're not sure we'll receive medical records by the time of the hearing. If we ask for continuance, how long of a continuance do ALJs typically grant? And our answer is it really varies. It really just depends on the ALJs and what their dockets look like. For some ALJs, it might be as short as 30 days. For other ALJs, it might be at least 90 days or longer. Sometimes it might be 4 or 5 months. So it really just depends. But one possible way of handling a situation like this is if you feel like you have enough records to go on to represent someone at hearing, but maybe not enough records to present the strongest case possible, you can go forward with a hearing, but then ask the ALJ to leave the record open for 30 days. So you can submit additional records highlighting, all the things you discussed, supporting all the things that you discussed at the hearing. And how do you register for the ERO? Oh, actually, I'm sorry, I promised over that we would release you after this. So are there any other questions that people have?
We've had one additional question come in, Nina, and I will leave up to you and Ilana whether we answer today or hold that for Thursday. But how long does the appeal to the Appeals Council take?
Hi, sorry about that. It can take many months for the Appeals Council to reach a determination after a request for review is filed. We will provide the average turnaround time tomorrow. Encouraging you to attend, not tomorrow, Thursday. Encouraging you to attend on Thursday.
Well, I think if there are no other questions we're going to tackle today, and I think we've kind of met our time limit, I look forward to seeing you all on Thursday at 10 a.m. Thank you so much for your time. Thank you to our presenters. Hope you found it informative, and we'll continue on Thursday. Thank you.